Hopefully that is working, and I am on YouTube streaming. My name is Michael DeToli. I'm here with Massachusetts Recall. Today, I'm going to talk a little bit about the initiative petition that a group of Massachusetts residents have put forth and discuss the process of getting a constitutional amendment that allows for recall of elected officials on the 2026 ballot. If you are new to this, please check out our Facebook group. I did put a link in the description. It is called I think it's called the Massachusetts Recall. It was formerly Michael W. Morrissey, and I'll explain why a little bit later. Yeah, hopefully this is working. I wanted to also have you subscribe to this page because I'm going to be doing updates and I want people to be involved. It's going to take a lot of people, particularly volunteers, to make this happen. So I'll go over the timeline and explain what that is, but you'll see that it's going to take a lot of manpower, and I'm going to need a lot of people in a short amount of time, especially to make this happen. So I'll quickly show you what a initiative petition is, because I think some people are unfamiliar, and you go to the ballot with a statewide election and you vote for a lot of the ballot questions, and you probably wonder where do they come from, and they come from people. So if you look at the Massachusetts Constitution, there is something called Article 48. Which is about initiative petitions. Scroll down here. Right here. So this is basically in 1790, the founding fathers of Massachusetts, at least, were very intelligent, thinking that legislative power should still be vested in the people. So there is a process once a year that you can put together a petition and bring it to the Attorney General's office, and basically you work with them to get it certified. So that is where we are in the process. It does take a little bit of effort because you have to write your either amendment or law, which we have done, and then you need to get a group of people together that sign to it, which we have also done. And you actually only need 10, but there is a little bit of an added step of going to your town clerk and getting some registration certificate. It's not a big problem, but for some people, you just need to take the time to go over. So we got that. And so actually we submitted this right in time because there's only once a year where you can do this. And this happened to be in August when a group of people came together and realized there was no recall provision in Massachusetts, which is why this sort of thing happened. So you can look at Article 48 if you want, but within Article 48, it does talk about some limitations. So you have to make sure that you're not, violating freedom of speech. You have to make sure that whatever you're proposing isn't religious-based. There's a few other things as well. So it's not easy to get certified. You do have to put together a little bit of a legal brief to convince the Attorney General that this is not in violation of freedom of elections and things like that. And you'll look at some of the ones that were submitted this year, and you'll see there's a lot that will probably be declined, and some will be accepted. So when you go to the, when you do go to the ballot box, there's not 52 questions. It's usually like 3 or 5. So I'll show you kind of what is in the pipeline and where we're at. But basically, we are in the process now of being certified. So we have on September 6th, we're either going to get a thumbs up or a thumbs down from the Attorney General. If we get a thumbs up, that means we can start collecting signatures. You actually need to collect 75,000. So it's a short amount of time. You have about 2 months between September 6th and I think it's November 20th that you have to go out and collect 75,000 signatures that certify. So you really need to collect like 100. It's not an easy task, but obviously with people mobilized, we have about 450 people on the Facebook group right now. So if everyone took the time to just spend a Saturday or Sunday collecting 150, 200 signatures, we'd bang it out pretty quickly. But I don't want people to collect signatures unless they know what they're collecting signatures for. So I did want to go over our initiative petition. There is language in Article 48 about some of the other things. I won't read it now, but it's there for you if you want to read it on mass.gov. So if you're on mass.gov and you put in like I don't know, you could put in Massachusetts recall or Initiative Petition. And ours is actually 23 for the year 2023, 15. It should come up. Yep, so here's all the ones that were submitted last year. Here's this year. And there were actually, I think, 42 this year. So ours is 15, which is right here. When you click on it, it will take you in, and you can take a look at it and read it. It's basically the same thing that every other state would that has recall would have, and I'll kind of talk about what that is. Essentially, I referenced Article 8 of the Constitution. That's the Declaration of Rights, which basically says people have the right to recall. In order to prevent those who are vested with authority from becoming oppressors, the people have a right at such periods and in such manners they establish their frame of government to cause their public officials to return to private life. So that's basically giving permission to have these recall elections, which we have at the city and town level in a lot of places in Massachusetts. There are actually 19 other states in the United States that have recall provisions at the statewide level. So Massachusetts is kind of behind on that. For whatever reason, it's just never come forth. So, come back to this real quickly. So, essentially establishing the right to recall, the people of Massachusetts reserve the power to recall an elected official. Naming those, because under Article 48, you can't just say we're going to do, we're going to add this amendment that's going to only recall governor. It's only going to recall the district attorney. You have to do it. It's kind of all or nothing. So that would include the governor, lieutenant governor, secretary of state, attorney general, treasurer, auditor, state senator, state rep, district attorneys, sheriffs, governor's counselors, goes on, register of probate, register of deeds. These are people you probably don't even know exist, clerk of courts, county commissioners, county treasurers. So the grounds for recall, this is kind of where you have to be as specific as you can, because you certainly don't want recalls for everything. And I know there's California gets a bad reputation for always having recalls, and they've had a lot lately, which isn't always a bad thing, and they don't always pan out. But essentially, you don't want to make it too narrow. So we have malfeasance, misfeasance, and nonfeasance. And I'll talk about what those are. And they're very relevant to district attorneys, especially if you're following what's happening in Norfolk County right now. There's a lot of those things happening in the trial of Karen Reed. If you look at B, obviously the conviction of a felony, you would hope somebody would resign at that point, or other serious crimes involving moral turpitude. So it seems kind of loose and vague, but it's actually not. And I'll kind of define what those things are in a few minutes. The actual process would be initiating the filing of a recall petition with the Secretary of the Commonwealth. And you have to basically get 25% of the total votes cast in the person's most recent election. So, again, using the district attorney of Norfolk County, in the last election, 2022, Michael W. Morrissey, he was the only one on the ballot, but 287, almost 288,000 people came out to vote in that election. So 25% of that would be 71,000. So you'd have to get 71,000 signatures just to get the recall initiated. So it's not an easy process. Clear and concise statement of the grounds for the recall. The person continues to perform the duties of office until the recall election is certified. So you don't just get the 25% signatures and the person's recalled. They don't vacate their office. So there would be a recall election. That person is, still in office because they haven't been recalled yet. And then it would be 35 days from the date of the verification of the signatures that there would be a recall election. And that would be conducted in accordance with the laws and procedures that we already have in place for elections. All right. then there would be a successor election. So in the event of a successful recall, that position would become vacant. That person could run for that seat. There's no limitation there. However, there would be an election within 60 days to fill the vacancy. The governor can put this in here because you obviously don't want to have an empty office. The governor can appoint an interim officer to the vacant position until the special election is certified. And obviously, if the governor was recalled, then you temporarily have that position filled by the lieutenant governor. And that's pretty much it. It's pretty basic. Here's the signatures of those that were official sponsors. And that's that. So it's pretty straightforward. It's taken not exactly, but it's very similar to the other 19 states that already have recall provisions in their constitutions. So if you wanted to take a look at, Louisiana and Wisconsin and California, you could see what their percentage of signatures required would be and what all the deadlines are and things like that. But it's pretty much all going to be about 25% of voters in the last election. I think California governor is like 12%, and maybe that's why people think it happens often. Actually, it doesn't happen very often at all. As a matter of fact, how many governors have been recalled in the United States ever? 2. So the first one was in 1921. It was the North Dakota governor, Lynn Frazier. He was recalled. And there wasn't another successful governor recall until 2003, when Arnold Schwarzenegger famously became the governor of California when Gray Davis was recalled. So it's not really as common, especially at the governor level, as people think. But it is pretty common at the district attorney's level. And I'll explain why real quickly. I came across, this is actually in Mass General Law or Supreme Judicial Court Rules of Professional Conduct of Prosecutors. And if you take a look, this is Rule 3.8, prosecutor in a criminal case shall refrain from prosecuting where the prosecutor lacks a good faith belief that probable cause to support the charge exists. So that was one that I thought was interesting. Also, D, makes timely disclosure to the defense of all evidence of information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. So I thought that was kind of interesting as well. And down here, there's some comments about just overall, the prosecutor has the responsibility of a minister of justice and not simply that of an advocate. The responsibility carries with it specific obligations to see that the defendant is accorded procedural justice, that guilt is decided upon the basis of sufficient evidence, and that special precautions are taken to prevent and to rectify the conviction of innocent persons. So you can see how, obviously, with any court case, certainly criminal case, certainly murder case, there'd be a lot of eyes watching and people, concerned about the prosecutor's behavior. And there are some kind of loose guidelines, but it's really subjective. It's very much in your own opinion of how someone is sort of performing. But this article here talks about a 2003 report identified 2012 cases across the U.S. in the last, 30 years, in which a judge reversed a conviction, reduced a sentence, or dismissed charges at least in part because of prosecutorial misconduct. All right? And then only 44 cases of misconduct actually resulted in any disciplinary review of the prosecutor. So you can see that it's very loose. The prosecutors have a lot of room to work, which in a lot of ways they should. However, you can also see ways that they can use that to their advantage. And I think that's what sort of prompted this idea to do this recall. Few other things here. This was actually in Massachusetts. This was a case where some evidence was destroyed. It was actually a fetus in a rape case. And they basically said, any prosecutor who destroys evidence, you are absolutely, especially if it's exculpatory evidence, you are absolutely in violation of your duties. And so, I think that's an important piece to note there. Few other examples of where district attorneys, because I think this is, again, where a lot of the corruption happens. So Suffolk County in New York a few years ago, I think it started in 2017, district attorney named Thomas Spota. He was finally charged, and I think he got sentenced to, it looks like, 5 years in prison for witness tampering, and also obstruction of justice. So you can see that there are times he resigned, but there are times when, unfortunately, district attorneys are not doing their job, and you might want to have a recall. San Francisco just famously recalled their district attorney, Chesa Boudin. This was a couple years ago. People were saying a little too progressive, a little soft on crime. So he was recalled. There was a recall effort to, again, in California, this time Los Angeles, to recall another district attorney. That one actually failed. So they don't always pan out. And then there was actually just, I think it was 8 or 9 days ago, an effort to recall Pamela Price. So she's a DA in Alameda, which is, I think it's near San Francisco, I believe. So there's a movement there to recall her. So again, this is a tool in the toolbox that if you have a district attorney that you don't necessarily, you're not too keen on keeping, you'd probably want to take a look at having a recall. Massachusetts does not have a recall at this point. This is why we're talking about adding it. Real quickly, the definitions of malfeasance, misfeasance, nonfeasance, and then I'm going to show you a couple of clips. Hopefully the audio plays, and maybe you can tell me what's happening. But basically, malfeasance, and again, this is in our document. We're talking about, these are things that an elected official, if they were involved in, they would be removed. So we're talking about intentional, deliberate misconduct. So if you are somebody who speaks maybe a Latin language, mal is bad. So this is basically someone whose behavior or something that they're actually doing intentionally is unlawful. So in the context of a district attorney, that might involve actions that breach ethical standards, legal duties, professional responsibilities, like fabricating evidence, knowingly presenting false information or testimony in court, engaging in bribery, of course, or corruption, accepting money or gifts in exchange for influencing the outcome of a case. All right, so that's malfeasance. Misfeasance, kind of the opposite. Think about the word mistake. It's basically where you are you're performing a lawful action, but you're doing so in a negligent or improper manner. So maybe you're kind of clumsy or just a little incompetent. So an act that should have been carried out correctly but was done incorrectly or carelessly. So for a district attorney, again, that might be mishandling or mismanaging critical evidence, maybe leading to its contamination or loss, or failing to properly prepare for a trial. That could be misfeasance as well. And then the last one would be nonfeasance, and that is basically, you're not doing anything. So your omission to perform a required duty, or failure of a public official to perform a required duty or obligation. So in the context of a district attorney, that would be situations where you neglect to take necessary actions. You receive credible evidence suggesting a defendant's innocence, but fail to investigate further or disclose this information to the defense. So that would be nonfeasance. A district attorney neglects to file charges or pursue a case despite having sufficient evidence to do so. That's obviously nonfeasance as well. So those are three kind of legal terms that you'll see in the document, and you'll understand that those are measurable. So if you look at, and hopefully the audio comes through on this, if you look at, this was in court in the Karen Reed case. This is the assistant district attorney representing the Commonwealth. And if you hear the audio, you'll maybe just take a guess. Is this malfeasance? Is this misfeasance? Is this nonfeasance?
I don't want to keep reiterating this. I spoke about it in the the last court date, but the health data for Mr. O'Keefe's phone has him taking 133 steps at 8:08 in the morning, 68 steps at 8:25 in the morning, 87 steps at 7:57 in the morning, 81 steps at 11:06 in the morning, 109 steps at 11:18 in the morning, and then 46 steps at 11:56 in the morning. The issue with that, as far as being able to rely on any of that data for anything whatsoever, is that Mr. O'Keefe was pronounced deceased at the Good Samaritan Hospital at 7:50 in the morning. So all of these steps, all of these feet, all of these things that he is traveling are after he has passed away.
All right. So is that malfeasance, misfeasance, nonfeasance? Is that intentionally, deliberately fabricating evidence or presenting false information in court to secure a conviction? I would say that is. I would say that's a mild case of malfeasance right there. Let's take a look at another one. This is, see if you can hear the attorney in this one. This is Karen Reed's attorney.
Your Honor, are experts available to do the exhaustive August 1st? The issue is that there's about 30 items of evidence that need to have DNA testing. Trooper Proctor, according to reports, only submitted about 5 of those for testing. Our office has been requesting access to the remaining items of evidence for 6 or 7 months at this point, and we still have not received access to those.
All right, so the 5 items that have been sent have not been able to be tested because some of them have exhausted?
A couple of issues.
I could keep playing that, but obviously you can hear there's something going on there. Is it malfeasance, misfeasance, nonfeasance? That's nonfeasance because district attorney is basically not doing what they're supposed to do. And I think they were actually compelled to send that evidence. So you can clearly see these are measurable, and if you actually sat down and watched some of these hearings, some of these pretrials, you could quickly see that there's a lot of cases to be made. So there's a group that sat down in July and said we'd really like to look at recalling the district attorney. We spoke with the Secretary of the Commonwealth. We spoke with the different town clerks and city clerks in Norfolk County, and everyone was kind of scratching their heads. The Secretary of State basically said, you can't recall a district attorney. That provision does not exist in Massachusetts. So that's why we wrote this amendment. Not going to spend too much more time talking about corruption because I do want to talk about ways that you can get involved. But essentially, corruption it's a problem everywhere. I mean, this is not unique to Massachusetts, but it is nice to have a remedy. It is nice to have some sort of a tool that you can say, especially when people are running unopposed for many, many, many years, and they get a little complacent, they get a little comfortable, and you might want to, have at least that as a threat or a way to at least, utilize and remove corruption. There are some some documents you might want to take a look at if you're interested, but these are all things related to the recall. If you look in the Facebook group, there's a link called Files, and you can take a look at some of the things that we've had to put together to show that there is precedence for this. So that, as well. If you had asked me before, I'd say it was like 50-50 we're going to get certified on September 6th, but now I'm saying it's probably like 65-35 because it's looking like we will get certified. And I got an email today from the Attorney General's office with some draft summaries that they would want to use for us when we start to collect signatures. So the key point is that we're going to need a lot of people. We're going to need a lot of bodies. And if people could help us in one way, I think it would be by right now clicking on the contact information. I put that in the description, and just putting in your name, your email, where you live, if you want to give us your phone number, and then would you be willing to help collect signatures? Because we need to collect 75,000, probably more like 100,000. And it's going to take bodies. It's going to take people all over Massachusetts. It doesn't matter if you're in Barnstable. It doesn't matter if you're in Plymouth. It doesn't matter if you're in Hampshire County, Worcester County, whatever. We just, we're going to need people. We're going to need bodies. We're going to need to organize. At some point, if we find out on September 6th that we are certified, we will have to organize with the Office of Campaign Finance and Management and basically, start up a committee. And all of that takes people as well, because we're going to need people to deal with fundraising and all that kind of stuff. So essentially, if you could at least join the Facebook group, if you could at least subscribe to this page, if you could at least give us your contact information so that we know how to get in touch with you, if you are willing to volunteer, those things are going to be really important. So if you have any questions, there is a email, massachusettsrecall@gmail.com. You can always put questions here in the comments. You could put questions in the Facebook group, anything like that that you need answered. But in the meantime, please, if you are somebody who thinks that there is some corruption taking place, maybe at the district attorney's office, maybe in Norfolk County, maybe somewhere else, and you feel like in Massachusetts it would be nice to have the opportunity to recall elected officials, people who get a little bit too comfortable in their roles, please join our movement. Please give us your contact information so at least we can keep you up to date on what's going on. And please help volunteer by helping us collect those signatures. So that's all I have for now. We will hopefully see you again in maybe a week where we could talk a little bit more about what's coming up. And then in 2 weeks, we will know for sure if the Attorney General has certified us, and it will be time to collect 75,000 signatures. So thank you very much, and enjoy your afternoon.